I think we're just going to go ahead and get started. I want to thank everyone who's currently with us for joining us. My name is Kimberly Kay. I'm the Operations and Editorial Director for the Legal Insurrection Foundation, where I have been for quite a while since its inception. Had the privilege of working with Professor Jacobson for almost 9 years now. It'll be 9 years next month. And I want to welcome you to this online webinar that we're hosting. I'm just going to go over a handful of housekeeping things very briefly, and then we'll get started. First and foremost, this programming is free. We are completely and totally donor supported. We put every single donation we get right back into the work we do, which is work we're very proud of. It keeps us very, very busy. We're not an organization that throws big parties and publishes things just for the sake of publishing things. We do the work. And it's a privilege to be able to do so. So for those of you who have donated, we thank you. And if you have not and are compelled to do so, later on, I will be dropping a link in the chat. I will be monitoring the chat and the Q&A throughout the course of this webinar, in which we'll be discussing what's happening with affirmative action, or at least our best guesses following the Supreme Court decision. So if you would keep your questions to the topic, not other cases, not other decisions, but if you would keep your questions focused on the subject that we're discussing today, that would be tremendously helpful. If you will put your questions in the Q&A section, so there's two sections if you haven't joined us for a webinar before. There is the chat section. Feel free to engage with one another there. We do ask that you keep it civil, not something that I feel I need to be concerned about, but do feel obligated to bring up. So if you can chat in the chat section and put your questions for Amir and Professor Jacobson into the Q&A section. I'll be monitoring those, and we'll get to as many questions as we can today. This is being recorded, so if for some reason you aren't able to attend the entire thing, sometime probably later next week, we will be publishing it on the blog. And so without further ado, I just want to briefly introduce our panel. Of course, we have Professor William Jacobson, who's the founder of Legal Insurrection and also a project of the Legal Insurrection, which is the Equal Protection Project. And we have Amir Benno with us. He is our litigations director for the Equal Protection Project. And so I'm going to quickly pass this on to Professor Jacobson.
Yeah, hi, thank everybody for coming here on pretty short notice. We picked this time not knowing when the decision would come down, and I think it was pretty good timing. I'm not going to say a lot other than this reminded me waiting yesterday for this decision of when we were all doing that for the Obamacare decision back in 2012. Although this time we had a better result than we did back then. We didn't know till the end how it was going to turn out. So what I'm going to do in the format we're going to do is I'm going to turn it over to Amir, and he'll talk about this decision and what just came down. I'm going to then talk a little bit about some of the dissents and what those mean, and the concurring opinion by Clarence Thomas. And then we will talk about really why we're here, which is what is the future? What does this mean going forward, both for the nation and for us as an organization? So with that, I will turn it over to Amir.
All right. Well, thank you all for joining us today. Very important decision. It's great to be with you, Kimberly, and with you, Professor Jacobson, discussing this case. And so let's jump right into it, which is just to give a little bit of historical context as to how we even got here. We're just going to rewind a little bit back to 1978, the Bakke decision, which had to do, it was a splinter decision, the Supreme Court, and really sort of the decision that sort of rose to the top was Justice Powell's decision in that case, where he recognized that there might be a compelling government interest in diversity in the student body, that provides with some sort of interest in educational diversity will help the students in some way. And over the years since the Bakke decision, the courts were sort of going this way and that way, trying to decide whether or not Powell's decision, which was a lone decision, he didn't join with the concurrences in the case, was really precedential or not. That got resolved in 2003 in a case called Grutter versus Bollinger. And that's really the case that this one that we just got the decision on yesterday, or 2 days ago, Students for Fair Admissions, is addressing. And that was a majority opinion written by Justice O'Connor, where the court conclusively stated at that point that there is a compelling state interest in diversity in education. And why, for those who might not be familiar, what this whole compelling state interest is, we got to actually rewind further to the 14th Amendment. 14th Amendment contains the Equal Protection Clause, which says that that states must provide to all persons equal protection under the law. It doesn't speak in racial terms. It doesn't speak about color or ethnic heritage, national origin. It talks about people. And the question then became, and it also, by the way, gave Congress the power to enact legislation to enforce that law, which it is also going to come up in this case, because it used that power to create Title VI, Title VII of the Civil Rights Act of '64, and that gives legislative power. But let's get back up to the Grutter case. When we're dealing with a supreme constitutional right that might be infringed in some way, the courts evaluate those rights, the infringement, under a two-step analysis. And Justice Roberts, in this decision, Students for Fair Admissions, says it's a daunting two-step analysis. The first one is there a compelling government interest? And second, is what the state actor has done, is that narrowly tailored? In other words, is it necessary in order to achieve that government interest? And what Grutter decided was that there is a government interest in diversity. And then they went through and said, well, here's how we can narrowly tailor that. And it set out a sort of a three-step process of what we have to look at in order for these sorts of race-conscious admissions programs to be necessary to achieve that government objective. One, it can't allow race to devolve into an illegitimate stereotyping exercise. That was what it said. Second, race can't be used in a negative way. Okay, so you can't discriminate against, you can't use it to discriminate against racial groups that were not the beneficiaries of the race-based preferences. And third, the race-based preferences have to end at some point. Okay, those are the three things. And what Justice Roberts decided in this case, first and foremost, diversity is not a compelling government interest. And that is perhaps the most important takeaway from this, because that's what overturned the precedent in this case. And then he went through and he said, and by the way, you haven't satisfied the Grutter standards either. So the Grutter standards, those three things, that trilogy that I just talked about, he says those weren't satisfied. And by the way, the court could have said, we're not going to address the issue of whether this is a controlling government, a compelling governmental interest. We're just going to address whether or not Harvard and UNC satisfied Grutter. They could have sent it back on that basis, but they chose not to. They chose not to, and that's going to have lasting repercussions. So why did Chief Justice Roberts and the majority here find that there was no compelling interest? Well, first, Justice Roberts' opinion says diversity, okay, writ large, is just too ambiguous. How do you measure whether there has been educational benefit in this case? So the schools have been saying that the benefit is training future leaders in the public and private sectors, is preparing graduates to adapt to increasingly pluralistic society. 3, better educating the students through diversity. And 4, producing new knowledge stemming from diverse outlooks. So the court says, these are all noble objectives. Those are great, but how do you measure them? And how is a court supposed to make sure that we're on track to have measured them? And how do we know if we've succeeded? And without knowing whether we've succeeded or whether there's some metric in place where we can quantify whether we're doing a good job or not, it's just too ambiguous. And so you can't have a standard that defies judicial review. Also said that the categories that the schools were using, which by the way is based on an Office of Management and Budget memo from 1977, Hispanic, white, Native American, African American, these categories were never intended for the educational sphere. They were meant for government data heads to figure out how to compile certain data in other aspects of the government business. And so these categories were just far too broad to have any meaning. And they talked about how being Asian could be anything from Western Pakistan all the way to the Philippines, and that it encompassed all these different cultures that have nothing to do with each other. And in fact, historically, could have been hostile to each other, but yet they were lumped together. There was no category for the Middle East. They didn't fit into the Asian category. They were considered to be white. And so these categories, what is Hispanic, whether it includes Spain, whether it includes Latin America, it's just far too broad, so that it's so overbroad, in fact, that it was meaningless. And so they said that for those reasons, you can't have a compelling government interest in diversity writ large the way it's been done. And then they walked through the three Grutter standards, and they said, here, race has been used as a negative, because college admissions is by definition a zero-sum game. For every person who gets in, that means that there's somebody who did not get in. And so if you're giving a racial preference to somebody because of their skin color, that means somebody who did not have that skin color was disadvantaged. So fails Grutter on that level. Two, it says that the school's programs require stereotyping. We are collectivizing people here and assuming that students who share a race all have a shared experiences or shared viewpoints on life, have a global worldview that is all identical. And they said that is nothing more than crude racial stereotyping. And by the way, those individuals who have been merit-based, say who are African-American, who have achieved success, are going to be viewed as if they only got to those levels because they were the beneficiaries of affirmative action, which of course is the very evil that affirmative action was supposedly designed to eliminate. And finally, they said there's no logical endpoint to this. So Grutter, like I said, Justice O'Connor talked about there being no further need, hopefully, for affirmative action 25 years after that decision, which would have been in 2028, 5 years from now. But that was viewed by the court as not really any, that was an arbitrary number, first of all. And one I should mention that that Justice O'Connor in 2010, with the dean of Cornell Law School, in fact, wrote an essay walking that back, saying really what the 25-year thing was is we have to assess whether there's any social science that supports that these kind of racial preferences in fact have had any measurable effect. But they said that there's no endpoint in sight, and because of that, it fails Grutter's third step. So because there's no compelling government interest, and because it fails the narrow tailoring requirement, those three steps under Grutter, the court said that they are overruling. They said it impliedly. They didn't say explicitly, but they are overruling that Grutter decision. And that is the takeaway from the majority opinion in Students for Fair Admissions.
Excellent. Thank you so much, Amir. Professor Jacobson is going to discuss next basically the concurring and dissenting opinions and university reactions. So we'll pass that to Professor Jacobson.
Great, thank you. I wish I could see the people here because I'd ask for like a show of hands. How many of you ever took a critical race theory course in college or law school? Because if you did, then you've pretty much read the dissent of Justice Brown, Ketanji Brown, and less so Sonia Sotomayor. So the dissents were really, how dare you, that there's still racism, there's still disparities, that we can't just pretend that this has all gone away. And they were really talking about something that wasn't the issue in the case. They were talking about more of a political, sociological, the case very narrowly. And Clarence Thomas really addressed this in taking on Justice Jackson, Ketanji Brown Jackson's dissent in a fairly brutal fashion, reportedly from an NBC News reporter in the courtroom when these were read. She was visibly angry. That's the term he used when Justice Thomas was reading his concurring opinion, which had a whole section devoted to her dissent. And basically, Justice Thomas, who fully joined in the opinion, the majority opinion, but wrote separately, said that this is really about the individual and individuals being treated fairly, and that the dissent, and he took a couple of jabs at Sotomayor, but really was focused on Jackson, said, that they're focused on groups, they're focused on group identities, they're focused on things that really amount to nothing more than racial stereotypes. And without any evidence that this sort of, additional level of racism accomplishes anything, is consistent with the 14th Amendment history. Where does that notion of, using current discrimination to solve past discrimination, where does that come from constitutionally? It's not there. So Justice Thomas really wrote a tour de force of taking down this notion of group identity and how it's not consistent with our constitutional structure, and how it really just amounts to racial stereotyping. And, he was very vigorous in contesting her recitation of the history of the 14th Amendment and other things. But, also he addressed from time to time in somewhat personal terms, his own observations, not that they were constitutionally really relevant, but how he's seen the country develop and how none of this is really going to accomplish anything. So, I think that was really significant. And Justice Jackson's opinion, I think in many ways, is the future of at least part of the judiciary that dwells on things like disparities in income. And he addressed that, how there's no real evidence to support that, and how a lot of it is comparing two things that are not the same, not adjusting for different factors that narrow those gaps, and several other things, and how we just can't go there, that in terms of a constitution that enables and encourages, at least as she interprets it, what amounts to racial retribution. That doesn't, advance anything. In his words, and I think this is, something that will be quoted quite a lot, he says, the Constitution continues to embody a simple truth. Two discriminatory wrongs cannot make a right. And I don't think he phrased it that way unintentionally, because the modern quote unquote anti-racism movement, as embodied by Ibram Kendi's How to Be an Anti-Racist, his most famous line is that current discrimination is justified to remedy past discrimination. And what Clarence Thomas is saying is, constitutionally, that's not true, that's not permitted, and that all forms of discrimination based on race, including affirmative action, are prohibited under the Constitution. And these are all things that are consistent with what the majority said. And so what I think this was, in many ways, it was a repudiation of the diversity, equity, and inclusion industry, philosophy, the so-called anti-racism philosophy. It really was a rejection of critical race theory as having any constitutional relevance. So I think that the concurring opinion contrasted with the two dissents is very important. And I think that's one of the big takeaways for us as people who have a website devoted to tracking critical race theory and a project devoted to fighting various forms of DEI discrimination. Is the Supreme Court has unequivocally repudiated the core philosophy that dominates the campuses and increasingly corporations. What that means going forward, I think, is to be seen, because the reaction has been fairly furious from the universities and from the Department of Justice. I just saw today the Department of Justice's statement, which says nothing about using their resources to actually enforce this ruling, to enforce non-discrimination. The entire statement, which is only a paragraph or two, was how horrible it is and how they will be providing resources to people which will allow them to pursue diversity in accordance with this ruling. So nothing about we're going to make sure that no one's discriminated against, everything about we're going to teach you how to walk right up to the line and not get in trouble. And that's really what every college statement that I've seen. I mean, you know, I got the Harvard email soon after this. Obviously, it had been prepared in advance. Everybody expected this to be the result. And it really was smug. It was almost taunting. We've quoted it in the post at the website. And the one thing that I, in some ways, fault the majority with, and this came in the majority opinion, if you've ever been in court and the judge is reading his or her decision and it's going all your way, okay? And then there's just like a stray sentence that really was unnecessary that gets stated that eviscerates your victory or lessens it. And that's what I found. There's a sentence or a couple of sentences right at the end that say, of course, none of this, and no one disputes, prevents universities, and I'm paraphrasing here, from taking into account individuals' experiences with race and racism. And in an essay or other form, but of course, you can't use the essay as a way to get around what we've just ruled. But of course, Harvard just said, yes, we are, okay? If you read it, and it's at our website, they basically, they quote that sentence, the first sentence, not the second one. And they say, we will obey the court. Very smug. They take the one sentence that seems to provide a loophole, and they say, that's what they'll obey, is the loophole. And so basically what I think you'll find colleges doing, and this was consistent. Some were a little less bad than others. UNC's didn't take that smug, dismissive approach. Cornell's didn't either, actually. Cornell's was a little more bland than that, you know, renewing their commitment to diversity, equity, inclusion, but not the snarky, smug reaction of Harvard. And so I think, and we'll talk about this a little bit more, I think, in the Q&A, but I think what you're going to see is colleges trying to hide the ball, doing everything they can to find other means of using race. And they'll say, oh, we're not using this person's race, we're using their experience with race. So that distinction between race and experience with race, I think, is going to become very big. And I think I understand why the majority said it, because it is true. None of the litigants disputed that someone can submit an essay showing how they personally have had to deal with discrimination, but you can't presume discrimination or hardship just from the color of their skin. So that was the one disappointment I had in the majority, is they opened that door a crack, said it's only open a crack, don't push it wide open, people. But Harvard is going to drive a truck right through that crack in the doorway. And yeah, we can litigate it, that's fine. This case took 8 years to reach the Supreme Court. 8 years. Harvard doesn't care. They literally don't care. Money means nothing to them. They've got a $50 billion endowment. They fought this for 8 years. They'll fight the next one for 8 years. So anyway, it was a great decision. I think, unfortunately, you're going to find more and more judges appointed by Biden who carry Justice Jackson's philosophy. I think Sotomayor was much more moderate, but carry that critical race theory approach to the law that one of our Supreme Court justices pretty much fully embraces. And I think that's the future of some part of the judiciary. So with that, I haven't been checking if there's questions or anything, but that's all I'm going to say for now. I have plenty to say later.
Yeah, so and thank you for your thoughts there. What I wanted to do, though, is to, just kind of for the sake of discussion, have a little bit more discussion before we jump directly into the Q&A section, and also give people a chance to drop their questions in there if they have any that they've yet to ask. And I want to preface this by saying I should have done this at the beginning, but I was so anxious to get started that we do a lot of work in this space. So we have the Legal Insurrection Foundation, and the foundation has a handful of projects. One of the things we do as a foundation is this. We provide programming, both online and in person, that's always free to attend. We do a lot of education on issues like this, other, legal ramifications, political issues, just all kinds of things. Mostly and almost always free speech related, though. That's the common thread in everything we do. And we also have the Legal Insurrection blog, which has been around for over a decade, which makes us unique for other foundations, because the blog preceded the foundation, which the foundation has been around for 4 years now. And so as two large projects of the foundation, we have the Critical Race website, which is just criticalrace.org, where we track critical race training, DEI, all of that kind of those pernicious ideologies that we see infiltrating education business on every single level. We track those on that website. It's a database. It's very, we're just providing information. We have a great team of researchers who work very hard to dig into these things and to find out what's happening at the university level, what's happening in medical schools, what's happening in law schools, what's happening in vet schools, even private schools around the country. That would be K through 12 private schools. Then we also have the Equal Protection Project, which is our newest venture, which is one that we're really enjoying because we've been very, very busy since we launched that just this February. And so the work that we've been doing there is directly related to this, and that when colleges are sponsoring programs that are flagrantly discriminating against people on the basis of race and ethnicity, we're finally at a place where we are able to get involved and to push back and to cause change. And so legal prowess of this panel and the rest of our team aside, there's a lot of information we have to share there. I'll put the link to that site if you have not been following our work there, but it's part of why we are very in tune to this space, and we know very well what's happening, and I think are probably more dialed into the ramifications and things we see coming down the pipe. Would you like to say hello? My son's here and he's peeking. Then I think maybe others out there. So just for the sake of discussion, and I'll just pose this to both Professor Jacobson and to Amir, so whoever wants to jump in on this, will this decision make any real difference?
I'll go first on that. I think it will. I mean, I think it will make a difference. It may not be the perfect answer we were all hoping for. And if they hadn't left the door open a crack, making the distinction between experience with race versus race, I'd be more optimistic. Yes, it will. I mean, the law is very clear now. There's no dispute. You cannot do this. You cannot use race as a determinative factor. Whether it's used in any given case will be a factual matter. So there will be disputes. The law is crystal clear now, and that is a huge advance forward. Nobody can claim they weren't aware, okay, unless you were like out of the country on a boat with no internet, during the month of June and July. You can't claim you're not aware, which we've actually, when we filed claims against universities, they say we weren't aware that this was a problem. Okay, so I think it will make a difference. I tend to focus on the negative. It's just my personality, but I tend to focus on what could go wrong. This is a huge decision, and nothing I've said really should detract from that. This is a monumental decision.
Do you have anything to add to that, Amir?
Yeah. Sorry, I was on mute.
No, that's okay.
So practically speaking, yeah, I think this is going to make a huge shift in how these cases get approached. Like, yes, will schools now start to use proxies for race-based preferences? Will they start to say, we're going to start to focus on giving preferences to students who apply from densely populated urban areas or something like that, which on their face they're race neutral, but in effect, they have a disproportionate impact, or they may yield more students of a particular ethnicity, or they may yield more minorities. So I think those kind of challenges, where you say disproportionate impact challenges, are going to be litigated. And one of them is teed up right now. It's a Virginia case. It's a high school called TJ, Thomas Jefferson. And in that school, the school was upset because they, much like in Harvard, they didn't like that the percentage of Asian American students was growing. And so they decided to change their admission standards by eliminating the admissions test that the Asian students were doing very well on, and to put in place some other superficially race neutral standards. And that's being challenged right now because it's pretty transparent that what their objective was to simply shrink the number of Asian students in their student body. So that is making its way through the courts. We can expect challenges like that to shed more light on how courts are going to analyze those. But the other thing that I think, two main takeaways from this decision that are going to impact the legal landscape are: one, there was a whole argument for decades about whether or not the 14th Amendment, when it was enacted, when it was ratified, whether it permitted there to be racial preferences in the law. And the school that sort of, not the actual academic school, but the school of thought, the theory, the anti-subordination theory, they call it, is that you couldn't use racial preferences to harm a particular, say, blacks, but you could use it to help them. And they tried to argue that the laws that were passed around the time of the ratification of the 14th Amendment and the Reconstruction supported that. Justice Thomas's concurrence in this case absolutely decimated that argument. And if you walk through his concurrence, if you read it, and if you also want to read the amicus brief from former Attorney General Meese, he deals with these specific arguments and absolutely demolishes that argument. So going forward, it's clear that that was not the intention at the time the 14th Amendment was put into place, that it was intended for a colorblind society, no favoritism for any race or ethnicity or otherwise. So that's a big takeaway. And the other thing that they mentioned in this decision, I think it was in footnote 2, I mentioned when I began that Congress has passed two statutes that we use a lot, okay? Title VI and Title VII. Title VI says that you can't discriminate on the basis of race in education if you're a program that takes federal money. Title VII says the same thing in the employment sphere. And those statutes are very specific. Whereas the 14th Amendment says no state shall deny to any person the equal protection of the laws, and it's sort of ambiguous, amorphous. Title VI and Title VII says no person on the ground of race shall be subjected to discrimination. I mean, it is clear. And the court could have decided this case on Title VI basis and said, we're not going to deal with the 14th Amendment. And we're just going to analyze this under the Title VI because it's a much stronger argument for those challengers. They chose not to do it. So they have essentially decided to view the 14th Amendment in lockstep with Title VI, which is an absolute prohibition on any discrimination. And whether that discrimination gives a benefit to a group or a burden to a group, it's equally impermissible. So, those kind of takeaways from this decision, what the 14th Amendment meant, the original understanding, and how we're to interpret it with the statutes, Title VI and Title VII, are going to have a big effect going forward on how these cases get brought.
Yeah, I mean, just to mention, one of the ways that's already been used to try to evade these laws in the Constitution is just like in Virginia, in Boston, they used zip codes. So zip codes became a factor. And by doing that, they managed to reduce the percentage of Asians, and I may be off on the percentages, but dramatically by 20+%, I think it was. because they now factored in the zip code you came from. So it was called the zip code diversity plan or something like that. That's working its way up. It was actually upheld in the lower court. I think what you might see is a lot of people who are trying to get to the Supreme Court on these issues. Supreme Court will vacate and remand the negative decision for reconsideration in light of this. So I think this is going to have a ripple effect fairly soon on those who already have tried to evade what the common understanding of the 14th Amendment and the civil rights statutes.
Which kind of leads me to the next question I have that Amir touched on briefly is, what does this look like outside of higher education? And is there anything that indicates to either of you that it would affect private corporations?
Well, I'll just say that, again, they were really clear. The 14th Amendment allows no racial benefit or preference. And they're saying that the 14th Amendment is going to be viewed consistently with Title VI, which prohibits discrimination. And there's no real principled reason why they wouldn't apply the same analysis to Title VII, which applies to the employment sphere. And so giving racial preferences in hiring or in promotions or that sort of thing, I think there's just not going to be any tolerance by the courts, or there shouldn't be, for that kind of activity.
Yeah, I think that's right. I think while I have no doubt some people will say, well, that was just higher education. I don't, this was such a forceful majority opinion. I don't think that's going to fly. I think that this will have an impact on judges down the line and on administrative agencies down the line. Certainly we're going to use this. So, even if you don't have necessarily state action, things like that, I think even in the private sphere where you have statutes that apply to private employment, and virtually every state does. I mean, blue states have probably stronger anti-discrimination state laws than red states, whether they're enforced or not. So I think this is going to have a huge impact on the private sector outside of higher education, even if this case took place in the context of higher education and in the context of admission as opposed to employment or other things.
The only place I can see that, I agree completely. I should have said Title VII obviously applies to the private sector. You don't have to be a state actor. The one place in higher education where they drop a footnote and they say there may be sort of a carve out for this is in the military academies. And the argument was that the officer corps needs to be representative, at least look similar to the enlisted. And if you have an officer, corps that's all white, but the enlisted are not, that might defeat some cohesion in our military. And because that has national security implications, the court said, we're not going to deal with the service academies here. So with respect to that aspect of higher education, they sort of have, it's sort of a sui generis thing. We're going to deal with that because they have particular issues that are relevant to them that don't apply to schools like Harvard and UNC.
So I guess kind of looking forward here a little bit for the work that we're doing with the Equal Protection Project, where we are engaging these universities attempting to discriminate. Do y'all think that's going to make our job harder or easier? Is it going to stay the same? What's that going to look like moving forward?
I think it's going to make it harder because you're going to find a lot of evasive context. We've already seen this in many of the actions we've brought where they use euphemisms. Historically underrepresented minority, first generation. Presumably they've looked at the numbers and first generation college students are less white than third generation. So they're going to start to use euphemisms. So it's going to be harder. They're not going to be as bold as they've been so far. So I think it's not going to change, I think, a lot of the problems, but they will be pushed underground a little bit more. They will take place more behind closed doors. You will also find, and this is really a purely admissions problem, and we don't really do admissions cases, but you're going to find a lot of schools getting rid of the evidence, but not getting rid of the discrimination. So they'll eliminate the SATs, which were so critical to the Asian students being able to prove their case. They will get rid of those objective measures or statistical measures. And so I think it's going to make our job harder.
Yeah, I would agree with with that, especially if, you know, right now, if certain schools are being very overt about the fact that they're giving preferences on the basis of race, and they're just saying it on their website, and it's astonishing that they do it, but they do it, and so that we can expect is going to change, whether or not the proportion of students who they admit from any particular group changes. That's obviously it's going to be harder. It's going to be less transparent. I don't know that it's going to be opaque, but it's going to be less transparent. The one thing I will say, Professor Jacobson mentioned that there are some schools that are talking about, we want to give advantages to underrepresented minorities. To me, that category is flawed for the same reasons the court found that these checkboxes on the Common App are flawed, which are, they're just so broad, overly broad, they're completely meaningless. What is an underrepresented minority? And it seems pretty obvious that that's just code for engaging in racial preferences that are forbidden.
Yeah, or marginalized communities. Okay, that's another catchphrase. So yeah, so it will make, I think everyone who works in this area will make our jobs more difficult from an evidentiary point of view, from proving it. But they're not going to give it up. University administrators, their careers, their philosophy, their sense of self-worth is so wrapped up in virtue signaling over racial issues that this is not going to go away. So there's going to be no less work for us to do, but from an evidentiary point of view, it's going to be more difficult.
I completely agree. So thank you for sharing your thoughts on that. I'm going to go to attendee questions now, and this one is kind of a good segue. What about historically Black colleges? Are there any implications there, given the recent ruling?
Okay, so I have a limited knowledge of how they operate, but what I believe to be true is they do not exclude whites. So I think that's correct. Somebody can correct me if I'm wrong. While it is a historically Black college or university, I don't believe their admissions brochure says only Blacks can apply. I think it's more of a cultural sort of thing. So I don't think any of this affects that. You know, I don't read this opinion as restricting, if you want to call it uplifting, of different cultures and different groups, okay? As long as it's not done in a discriminatory way towards others. You can still have, you know, Black History Month or week or whatever it happens to be. You know, all of these things are still good. You can still, in my view, have historically Black colleges and universities. So I don't see this as really affecting it unless there's something in the regulatory structure that I'm not aware of.
And what I'd add to that is that's probably correct. I would imagine that part of the argument for them as well is that it is remedial, possibly in those particular geographic regions where they are, that there was a vacuum or something that they were originally conceived of to provide some type of remedy. And I don't read this affirmative action decision that just came out as getting rid of the ability of the government to engage in race conscious activities in order to remedy what was de jure segregation. And so if that still can be argued that this is necessary as a remedial measure for a specific geographical region and a specific area, then that may be an argument for them. But it's going to be harder now that the court has been much clearer that the 14th Amendment does not allow these kind of race conscious benefits to any racial group. In the past, they argued that there was these the Freedmen's Bureau Acts that were part of Reconstruction that specifically gave benefits to former slaves. And they said, well, that means that in the wake of the ratification of the 14th Amendment, that the government understood that amendment to be that we can give these benefits to former slaves. And this decision essentially eliminates that whole line of argument. I don't know what effect that has on historically Black colleges and universities, but I think it's probably relevant to the analysis.
Well, that's helpful. So this is similar, but different. University DEI programs. I know that, who was it? The University of Arkansas at Fayetteville or something like that, some branch, saw the writing on the wall. They willfully and purposely disbanded their DEI program. And what they did is they took those administrators and just scattered them throughout the university. I guess afraid that the state legislation would require them to do so, and there'd be far more oversight in whatever the state legislator decided. So in light of the ruling, what do we think is going to happen with university DEI programs? Because almost every single university, if not every single university, has a DEI office intact.
Yeah, well, distinguish, DEI from the sort of discrimination that took place here. So DEI can involve discrimination. It certainly could, but it doesn't necessarily. It's more educational philosophy. It's more social philosophy. It's more of whether we want to teach or train people to focus on race. I'm not saying DEI can't run afoul of the anti-discrimination laws, but they're not the same issue. It's not the same issue. So I don't know that this decision in and of itself mandates the elimination of DEI departments. I don't think it does. But to the extent DEI departments are doing things like holding events that are only open to people of color or things like that, then it does constrict their conduct. But I don't think it requires a university not to have a DEI department.
Yeah, I agree with that. I agree with that analysis. And the question, although this wasn't exactly what you asked, Kimberly, it reminds me just to mention that for all of the hand-wringing that we're going to see from the left about, oh my gosh, this is the end of racial equality, which is just quite simply not the case. Keep in mind that before this decision was issued, 9 different states had already passed state laws eliminating racial preferences in the admission process for higher education, and they haven't seen the drop-offs, precipitous drop-offs that the doomsdayers are saying they would have. In fact, in California, you're seeing like UC Berkeley's minority percentage is very, very high at that school. So for people who are clutching their pearls saying that this is the end, well, the data just doesn't support that.
No, it's great to know. I know the data tends to do that. If there is a side, it tends to not be on the hand-wringing, pearl-clutching side of this issue. So this is a little bit more of a specific question, but does the race box disappear completely, or does it stay on applications and cannot be part of the admission criteria? Can anyone speak to that?
Yeah, that's interesting. Does the box stay? I don't see why colleges need to know which box you're checking unless there is some other federal regulatory requirement for just data gathering that they have to do that. Okay. So I'm just not aware, barring some requirement for data gathering purposes. I don't think they need to know which box you've checked. Now they could design an application way if all they really want to do is gather data, that you fill it out, but the school doesn't actually see which boxes you've checked. And but I don't see why they need to know what quote unquote race you are if they're not going to consider it.
Right. And so this came up at the oral argument that the check boxes are on the Common App, which is not necessarily the specific application for the school. Harvard did have, I believe, a way to ask on their own application to get at your ethnicity and race. UNC made the argument, hey, we didn't do that. That's Harvard who did it, not us. Trying to make the argument, listen, fine that they violated Grutter, but we didn't. They made that argument at oral argument. So whether, like the professor was saying, there is some sort of data compilation necessity for the federal government statistically, remember these checkboxes were designed for that purpose, not for admissions. It's clear that they cannot be used in any way for admissions. So it can't be on the individual school's admissions application. The Common App, insofar as they remain on there, that aspect can't be reviewed or considered by the schools for admissions decisions. But whether it can stay on the Common App is a question I don't have the answer to.
Okay. Another question is,
Well, let me just talk to that. There's going to be no need for it anymore because the Supreme Court opened the door a little, and the colleges are going to probably take the exact wording from that sentence in the Supreme Court decision and have it as an optional essay. And they will quote, they won't put quotation marks around it, but they will recite it precisely the words that the Supreme Court used as to what they're allowed to do. And you can submit an optional essay and everybody's going to know exactly why they're asking that. And so there have already been a number of bloggers who've done, I don't even know what it's called, Chat GPT or something like that, to draft essays. Tell me, provide a 500-word essay for me about how I have overcome racial obstacles in my life. And so you're going to get a lot of that. People will be incentivized to volunteer their race, not as a race, but as overcoming obstacles. So that's how it will still come up. And the court said they can do that. So
I agree with that. And I just want to, because it's important, I want to point out that, so Chief Justice Roberts, throughout his decision, the majority opinion, makes these withering statements against Ketanji Brown Jackson. And one of them is what Professor Jacobson is remarking on here. He says, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. But despite the dissent's assertion to the contrary, so the dissent is arguing you can talk about race and you should talk about race, universities may not simply establish through application essays or other means the regime we hold unlawful today. And then he puts in parentheses, this is a barb at Justice Jackson, a dissenting opinion is generally not the best source of legal advice on how to comply with the majority opinion. Close parens. And so he does open the door, you're correct, but he specifically, gives her a little twist to the knife saying, don't think that the courts are going to just allow that to be a workaround. So we'll see what happens.
Yeah, I mean, the problem is we all live in the real world, okay? And we know that most people can't get lawyers to bring cases. It's very hard even for foundations to get the funding to bring cases. There are too few foundations on our side of the aisle, ideological aisle, that we don't have the infrastructure that the left has. If you remember, during the Trump years, whenever Trump did anything, the next day, there would be 8 lawsuits filed by 5 different public interest groups in courts around the country, and they only needed to win one of them. We don't have that infrastructure. We have corporations like Harvard, which have no problem fighting a case for 8 or 9 years, if that's what it takes. So yes, Justice Roberts put a lot of that language in there, and I'm happy he did. But in the real world, they have the universities are so wedded to this. It's so part of their fundamental being at this point in time that I think it's going to be tough, and they're going to totally exploit that little loophole that the Supreme Court left for them.
Okay. Next question. Is there something alumni can do to ensure universities will comply with the decision?
To ensure,
Well, the first thing is,
yeah, go ahead.
I was just going to say, the first thing is, if you see something come through in an email or from your school, let the Equal Protection Project know, go to their website, fill out the form, and send us a tip. We've got a number of tips that have come in through alums who have learned about programs at their schools. In fact, we filed a complaint against the University of Buffalo in New York, their law school, for engaging in a race preference program that came through an alum. And those sorts of things are something I think it's very discreet, something that an alumni can do to, at least put it on our radar.
Yeah, I was about to say, monitor, keep your ear to the ground. Universities, because they want your money, love to send you stuff. And they're sometimes oblivious to the fact that someone might think this program is problematic. So I would say, be the eyes and ears of whether it's our group or other groups that are out there doing work, and send us a tip. Not everyone's going to line up, but Buffalo Law School is one that came in because an alum received something from the school over a mass email. And I think we've received more than one that way. The schools love to brag about this stuff. They probably won't brag about it as much going forward, but definitely, because if something's not on their website, it's really hard for us to know about it unless someone tells us. So there may be things that are not generally on the website that are done through email, or if you're on campus, you live near the campus, you could see physical posters about things. But it's very hard for us to find things if they're not on a public website. So send us tips, please.
Yes, all the tips, very helpful. Do you expect, or do we have any expectation that the impact, or this will impact the way federal, state, and state municipalities make hiring decisions, or the way government agencies allocate funds to help certain kinds of big businesses, which all seem to include some kind of racial preference? I'm sorry, I cannot English today. Was that at all intelligible?
Can you say that again?
Do you expect this to impact the way federal and state municipalities make hiring decisions, or the way government agencies allocate funds to help certain kinds of businesses, which all seem to include some kind of racial preference?
Yeah, I mean, racial preferences are so embedded throughout our society. I mean, there's only so much we can deal with. We're small, but it astounds us all the time when we find racial preferences throughout government, sometimes passed by statute or ordinance. Okay, there's a lot more that needs to be challenged. So I think that this may cause counsel for various governmental agencies or municipalities to say, hold on a second here. Can we really do this? Whereas in the past, they didn't really worry about it.
Amir, do you have any thoughts on that? Or are you good?
No, I think that addresses it. I don't see how doing racial preferences absent some sort of remedial measure that fits into the very, very narrow category that's permitted would ever pass constitutional muster, especially now.
Okay. All right. So this is the last question I'm going to ask, and then we'll just go ahead and move on to final thoughts from both Amir and Professor Jacobson. Does the elimination of the SAT and ACT test requirements, reduction in emphasis on advanced placement courses, and elimination of other objective standards possibly help the colleges to achieve their diversity goals without violating this new Supreme Court ruling?
It doesn't help them achieve it without violating the ruling. It may help them make unlawful decisions that are harder to discover and prove. And that's really the issue, that if they're going to discriminate, they're eliminating the proof of it. They're not really eliminating the discrimination. I think it was, there was a Chris Rufo released yesterday, I think, a tape of the dean of Berkeley Law School saying the quiet part outside, which is I'm paraphrasing, but basically we have more leeway in hiring decisions than we do in admissions decisions, because we don't have the statistical proof like SATs. And then he says, and I know he'll say, oh, I was just joking. He says, I'll deny saying this if ever deposed. He literally said that. Now, it was a recorded thing, so I think it clearly was in jest. Okay, but he says, I'll deny saying this, but when we go to faculty hiring decisions, you're damn right we take race into account in ways we can't do for admissions. So, I think that's a lot of what we're going to be seeing.
Final thoughts? Bill, do you want to go first?
Sure. I just want to thank everybody for coming here, taking up your lunch hour on a Friday in the summer, right before July 4th weekend, before a holiday weekend, to join us. Following this, we've been following the Harvard case at the website. I don't know for how many years. I want to say for 5, 6, 7 years, which is what we do. We've probably got a dozen or 2 dozen posts about it as it worked its way through. So to see this come to fruition, and with a victory, unlike Obamacare, which is a much shorter period, I think was very satisfying. I think that it comports with what the American public wants. The polling shows, and my personal experiences, particularly with students, they don't like this stuff, okay? Whether they're willing to say that and have social media descend on them is a different question, but people don't like this stuff. People instinctively know that making decisions, whether it's admissions, hiring, whatever, based on the color of someone's skin is wrong, and most people don't like it. And I'm glad the Supreme Court has now said it, so I think this is very helpful, and thank you again for coming.
I echo that entirely. I think fidelity to the Constitution is obviously paramount, and it's really gratifying to see that the court is doing just that, and creating what is the colorblind society, because Justice Roberts said it long ago. He says the way to stop discriminating on the basis of race is to stop discriminating on the basis of race, and then he riffed on that in this decision. He said something very similar, and there are shades of gray here. It's you either are discriminating or you're not. And so I'm glad to see that the court finally said we're not going to tolerate it. The work that we do, obviously, we are fighting the current of the progressive current in the academy and in corporate industry and government, which really wants to go the other direction, despite what the Supreme Court says. So we have our work cut out for us, but we really do thank you very much for your support of us, for tuning in today, and for helping us accomplish our objectives. And I want to thank my Professor Jacobson and Kimberly for having me on today to talk.
Yes, of course. Thank you both so much for sharing your insight and your wisdom on this issue, and for everyone that joined us today. We hope you found this informative and valuable. We really appreciate you and all you do to contribute to the work that we're doing. Your questions, your emails, all of those things are very helpful. So we hope y'all have a wonderful holiday weekend, and we'll see you the next time we do this. Bye, y'all.
Bye.